Hello everyone, my name is Magda Raczynska and I'm here with Richard Calnan. Together we teach International and Comparative Secure Transactions Law module at UCL on the LLM. And the purpose of this video is to tell you about the reasons why it's important and interesting to study secure transactions at UCL. And I think there are at least two lots of reasons. One is academic and practical reasons. And Richard, you've got many decades of experience in practice of secure transactions. Why do you think it might be useful for students to study secure transactions law, and why it might be useful for them in the future as well?
Thanks, Magda. Well, I suppose I'm biased. I've been a banking lawyer now for the last 40 years, but I really do think that it's important in practice. The economy is run off credit, and credit is available in unsecured or in secured form. And of course, it's a lot easier to get secured credit than to get unsecured credit for obvious reasons. And so if you can create security, it's something which borrowers want to do. And one of the interesting things I think about doing this in practice is that both the borrowers and the lenders are actually moving in the same direction. They actually want to achieve the same thing, because the lenders want to get valid security, and the borrowers are very keen to ensure that they do, because if they do, that makes the lenders comfortable. And if the lenders are comfortable, then they're more likely to lend money. The one thing you need in an economy is confidence, and the confidence is obtained to some extent, at least, by being able to get security. So I think it's a really important topic in practice. And I think it's particularly interesting, and you may come to this as well, Magda, but it's interesting because it sort of is on the boundary of property law and the law of obligations. It's one of those things which straddles the two. The loan agreement is a matter of the law of contract. The security is a matter of the law of property. And so you get to deal with all those interesting property law issues, which you might otherwise not get to deal with. So I do think it's a very interesting subject, as well as a very important one.
Great, thank you. I too think that it's very interesting academically. So Richard's explained a few reasons why it's interesting in practice, but also conceptually. And I would like to add on to those. So when we come to study secure transactions law, we come to look at how the way the law developed. And in this module, while we do explore the comparative perspectives, we spend quite a bit of time on English law. And the reason we do this is so that we can examine the successful jurisdiction that has been applied in many transactions. English law has been quite successful over the centuries, and it's interesting to examine how this jurisdiction has developed. English law of secure transactions is a very good example of the English common law, by which I mean the law which developed over the centuries through pragmatic judicial decisions, responding to the needs of commercial parties. And I think academically, it's interesting to study how English law has come to be successful. So for those of you who are watching this video, you will probably have gathered that we will be spending some time in the module looking at case law. So there will be a fair amount of English case law reading, but there have also been some statutes, some statutory intervention in this area in English law, notably the Companies Act, Insolvency Act, and most recently the Corporate Insolvency and Governance Act, which we will look at. But by comparison to other jurisdictions and other common law jurisdictions, the statutory regulation in this area in English law has been quite limited. In civilian jurisdictions, France, Germany, China, much of the law of security is found in civil law civil codes, commercial codes, and other statutes, but also in jurisdictions that share the Anglo-Saxon heritage, USA, Canada, New Zealand, Australia. There are now codes that govern this area. So in the US, it's the Uniform Commercial Code. In other jurisdictions, Canada, New Zealand, Australia, the Personal Property Security Acts. So when we come to look at English law as the focal point of our module, we will come to see that it does look quite complex. So the question arises whether it could be simplified and modernized. And I think that's the second reason why it's academically interesting to study the area of secure transactions, to see how, whether it is too complex, whether it could be modernized, and if so, how. And the third reason for me why it's interesting to study this module academically is the one that Richard already talked about, which is that the module is an application of fundamental principles of private law, contract, property that Richard talked about, also trust, agency, assignment, all those concepts really come to life as part of this module and as part of the complex transactions that you may well have done or may well be doing in the future in project finance, receivables finance, and so on. So as part of this module, we try to examine key concepts and look at their relevance in practice. We will look at 10 different, we'll have 10 different seminars, and both Richard and I will teach on the module. The module in the year 2020-21 will be taught online due to the pandemic, but we will have both some material available to you and some material which we will discuss as part of live online sessions. And finally, the module will be assessed by a 3,000-word essay on a self-selected topic, which enables you to focus on a question that interests you, where you can look at this question in a little bit more detail and research it further. So I think you have gathered already that this is an area which is worth studying. Richard and I certainly think so. So I hope you found it useful, and see you at UCL.